Hello, everyone, and welcome. Thank you for joining us for today's webinar, Fashion Law 2025 Year in Review. Before we get started on today's presentation, I'd like to go over a few housekeeping items. For those of you who may have questions about any of today's topics, we invite you to type them into the Q&A widget on the left-hand side of your screen at any time. We will do our best to answer all questions at the conclusion of today's presentation, time permitting. However, if we do not get to all of your questions today, we will be sure to follow up with you via email. If you experience any technical difficulties with the webinar platform, please refresh your browser or see the webcast help guide on your screen, which is designated with a question mark icon. A copy of today's slides are available to download in the resources section. The recorded version of this presentation will be distributed to all registrants post-event. For those of you who are seeking CLE credit for today's event, please enter the CLE code when it is announced later in the presentation. Please note this on your electronic CLE affirmation form, which has been provided below in the live CLE credit widget. This form also includes an optional attendee survey. We appreciate if you could share feedback on today's webinar. CLE certificates of attendance will be distributed to eligible participants approximately 8 weeks after the webinar via email. And now I will turn it over to our presenters.
Thank you, Kelly. Hello, everybody. My name is Laura Ganoza. I am the co-chair of Foley's Fashion, Apparel, and Beauty Group, or as we call ourselves, Foley Fab. I'm so excited to be here for our 8th annual Fashion Law Year in Review. It's become a signature feature of our Fab group. And I'm thrilled. There are many of you here today who've been joining us since the very first one, so welcome back. And I see some new folks are also in attendance, so welcome. We hope that everybody enjoys the next hour, gets a lot of good information, finds it to be interesting, educational, and most importantly, that you have some valuable takeaways that you can take to your organization after this webinar. And for those of you who aren't aware, Foley's Fab Group is comprised of, I think, over 50 lawyers now throughout all the different offices in the firm who have deep experience within the fashion, apparel, and beauty industry, and we provide full services to our clients. And I'm thrilled to be joined here today for some of our fabulous members. First, we have Grace Fucci. Grace is one of our transactional lawyers, and she focuses on M&A transactions, private equity, investments, and generally advises clients, both big and small, on all different areas of business matters. So thank you, Grace. This is your second time being here, so thank you so much. We also have Emily Ostreich. She is one of our superstar lawyers in our trademark, copyright, and advertising group, and she's a right hand to me, advising our clients on their brand strategy, providing strategic counseling, and providing trademark prosecution services, copyright services, licensing, and in general, helping clients navigate and implement brand strategies. Emily, I think this is your third go around doing this, so thank you again for participating. And last but not least, we have a special guest here today. We have Kristen McGever-Sikora. She is one of our Fab members, but she's also a member of Foley's Consumer Product Safety Team, where she specializes in consumer product safety, compliance, and regulation. And we're so happy to have her here today so she can give us some insight into what she does every day, which is help clients design and implement compliance programs. And today she's going to be talking to us about labeling compliance. And it's especially important because there are new regulations, especially international regulations. So those of you that practice, that have organizations that are located internationally, you have to learn how to navigate all those different kinds of international regulations. And we're so happy that Kristen is going to join us to talk about that today. Also, again, we are in partnership, again, with the Luxury Law Alliance. And if those of you on the call don't know who they are, you should, because they are the world's premier global network for in-house counsel, founders, executive, and brand managers at luxury companies. They do a terrific job of providing educational opportunities and networking opportunities throughout the year. They have some signature events, including their luxury law summits, which started in London, but have grown to New York and now Milan. Here's some information about how you can get involved with the program, but we thank the organization for for participating and collaborating with us on our Fashion Law Year in Review again. So what are we going to talk about today? As we do every year, we are going to give you an update on the cases that we told you we were going to be watching, our cases to watch. We're also going to talk about something very trendy right now, and that's duping, of course. We're going to talk about self-duping as a brand protection strategy, but also give you some tips on coming in before that and see how you can set yourself up to combat duping to begin with. Like we always do, we're going to give you some updates on recent legislation that you should know about in the industry. For the B members of our Foley Fab, we're also going to talk about the medicalization of beauty and evolving regulatory standards in that area. Of course, we have to talk about tariffs and imports and what's going on with that, because that's something that heavily has affected this industry. So we'll give you some updates about that. Also, on the IP side, we'll talk about using patents and other IP developments that can help you in protecting your brand, your inventions, and overall bringing value to your company. As I mentioned, we have Kristen, who's going to be talking about labeling issues and compliance in this modern age where a lot of it is international. Grace is going to talk about some of the M&A transactions that have reshaped our current landscape. And of course, we'll end, as we always do, with the cases that we'll be watching for in 2026. So with that, I'm going to kick it off to Emily so she can start talking to us about the cases that we were watching for you this past year.
Thanks, Laura. Hi, everyone. So our first case that we're going to provide an update on is a class action involving Hermes International. And by way of brief background, this was a class action lawsuit filed against Hermes where the plaintiffs claim that Hermes allegedly violated U.S. antitrust laws by conditioning access to Birkin bags on prior purchases of other Hermes products. So last year, when we had our presentation, Hermes had recently filed a motion to dismiss the plaintiff's second amended complaint. And in September of 2025, the judge ruled on the motion and sided with Hermes, dismissing the case, and found that plaintiffs had failed to plausibly define a relevant market or show that Hermes had any market power. And so here's a quote from the opinion where the judge said, "Businesses may choose the manner in which they do business, absent an injury to competition." And here the judge found that there was no injury to competition, or that plaintiffs had not pled it, at least. So this was a good win for Hermes. Plaintiffs have filed a notice of appeal to the Ninth Circuit, so we'll continue to monitor this, and we'll probably come back to you next year with an update. The next case that we were watching from last year is also another class action lawsuit, and this involves Lululemon. Here the plaintiffs sued Lululemon, alleging that its Be Planet campaign misled consumers into believing that its products and businesses were eco-friendly when allegedly they were not. So last year, when we discussed this case, Lululemon had filed its motion to dismiss. And about a month or so after our presentation, in February 2025, the court granted Lululemon's motion to dismiss and found that the suit does not allege that there was any deceptive act or unfair practice regarding the products sold to the plaintiffs. So interestingly, the judge did not allow the plaintiffs to amend their complaint due to their own procedural errors. And so this case was closed in mid-February of last year. The next case that we have an update on is Goyard versus the shoe surgeon. And in this one, Go-Yard sued the shoe surgeon for trademark infringement, false designation of origin, and false descriptions of fact and unfair competition for the shoe surgeon's use of the Go-Yard trademark, as well as its distinctive monogram pattern. So the shoe surgeon was using these marks on their shoes. And at the time of our presentation last year, the parties had informed the court that they were negotiating settlement. And again, around February 2025 is when they filed a joint settlement, a joint stipulation for dismissal, stating that they reached a confidential settlement agreement. So this one has concluded as well. And then the final case that we were watching from last year is this case between Adidas America and Aviator Nation. This one has been going on for a long time, nothing new between these parties. Basically, it's a long-standing dispute between the parties over Aviator Nation's use of stripes on their clothing. So the parties almost over a decade now have entered into various settlement agreements over Aviator Nation's use of their stripe patterns. And this lawsuit in particular was when Adidas sued Aviator Nation, alleging that it breached one of the settlement agreements by using a 4 and 5 stripe design on some of their apparel that Adidas claims is confusingly similar to Adidas's 3 stripe mark. So both parties in November filed motions for partial summary judgment, and we are monitoring this case to see when the court will rule on these motions. So again, this will be one that we continue to monitor, and hopefully we can update you next year. And now I'm going to turn it over to Grace to talk about start our section on trending topics in fashion law.
Thanks, Emily, and hi, everyone. Thank you for joining us today. Our first topic, as Laura previewed, that is certainly trending this year is self-duping as a brand protection strategy. And as all of you probably know, duping is not a new concept, but recently we've seen brands get a little bit more creative about how to best combat the dupe market. More than ever with social media, TikTok, everything trending, dupes have garnered more and more attention, notably with the hashtag dupe on TikTok receiving over 6 billion views this past year. So this is certainly no time like the present for brands to get creative on how to work around the dupe market. Self-duping is a relatively new concept that's continuing to gain popularity. What we mean by this is brands coming up with their own subsections of their products, priced more affordably, but still maintaining the quality characteristics the brand is known and loved for. By way of example, Coach and Michael Kors have been in this space for a while with their collection of made-for-outlet bags, high-quality work, beautiful products, but sold solely through their outlet retail shops and at a more affordable price for consumers. As some of you may know, we're at the 10-year anniversary of Kylie Cosmetics, this 2026. And so this brand is also a good example of working on self-dupes with the launch of Kylie's mini versions of her key product, her lip kits. These are smaller sized versions, therefore priced a little bit more affordably, but still using the same formula, packaging, shades that can be found in her larger size products. So the benefits here for brands kind of taking on this self-dupe perspective are certainly, one, being able to control the quality of your product, the branding, and how you're introducing the more affordable version into the market. This is also a very effective way to expand your consumer base. Perhaps new people who aren't familiar with your product are more willing to buy in and experiment at a lower price point. Once your consumers hopefully love your smaller self-dupe product or more affordable product, this is a good way to build continuing brand loyalty and have your consumers keep coming back for more. However, we wouldn't be a law firm here without raising some of the other considerations or the disadvantages here with pursuing this strategy. So one of the more business-focused points here is that you are taking a gamble by pursuing the self-dupe strategy because you're handing consumers your product of excellent quality at a lower cost. So consumers who might have been willing to go ahead and purchase your signature item are now possibly going to be swayed to go the more affordable route. However, we are referring to this as a gamble because, of course, the flip side can be true too, in that once you have a consumer entering, getting familiar with your brand, they're going to stay loyal and continue purchasing more, graduating up to your signature line. One of the possible ways to kind of mitigate the flip side of the gamble here is by focusing who can actually access your self-dupes. So because Gen Z is really a hot consumer base that a lot of brands are trying to capitalize on, if your goal in primarily making a more affordable product is for these younger folks with less disposable income to enter, you can set up programs to kind of verify, the consumer is part of the Gen Z base, such by putting in, a student ID code. It has to be linked to a university email. More, you can set up different programs to kind of try and target market-specific sectors. One of the other disadvantages that is noteworthy to raise here in this discussion is you do run into a slight trademark dilution risk. If you're using the same logo, trademark, trade dress, and designs that can be found in your signature lines, but offering varying price points, that can actually weaken the association between the mark and your associated quality. So something to consider certainly, but there are also ways around this. For example, using Michael Kors and Coach, their self-duped products are offered exclusively in the outlets. So we're differentiating which channels consumers can find these products from the signature line, as well as varying, how you're presenting the products. For example, Kylie's lip kits are either lip kits or the mini versions, and it's very consistent trademarking to make sure we're exclusively calling the signature line the full-size lip kits, and the self-dupe in this case exclusively referred to as the minis. So I'll turn it over to Laura, who's going to go through a few more legal considerations on this topic that anyone in the industry should be aware of.
Thank you so much, Grace. Yeah, there's a few other considerations if you're thinking of the self-duping. So you should take a look to see if you're able to do it, making sure that if you have vendor agreements, that there's nothing in those agreements that are going to cause a problem, because maybe there's minimum quality standards, minimum pricing standards, or having a lower tier product may conflict with the obligations that you have in your contractual relationship. So make sure you look at those, have open conversations with your vendors to the extent that you can, in order to discuss maybe having these limited edition drops and things of that nature, to make sure that you're still in compliance with your agreements, but working through these issues in advance before you launch something. Also, as Grace mentioned, one idea is to make just kind of smaller versions of things and call it a more affordable kind of self-dupe in that way. But there's also risks with that. If you're not clear at exactly what is making this kind of the lower tier brand, if you're implying that it's identical in every way, but there's missing an important ingredient that's maybe more expensive, that could cause problems. So making sure that there's no material differences if you are marketing it as a complete, as completely the same as your main product. So you want to make sure that you avoid those kinds of things. If you're going to make a smaller size, make sure that the quantity is readily disclosed and conspicuous. So there's no issue that you are misleading the consumers with your own kind of self-dupe product. Another really important thing that we should talk about, though, is, maybe you don't want to self-dupe. Maybe you want to continue with having just one tier of the quality that your consumers know and love, but you still have this duping problem. So what can you do to deal with that? And the most important thing is, buttress what you believe is what is worthy of protection. And in this case, trade dress as a form of IP can really be a really strong foundation in order to combat duping. And one of the best things to do is to build that up and make sure that that is a very strong foundation. What do we mean by that? Here are some examples that we give you of things to do to try to bolster your ability to claim that you have very strong trade dress protections. First, have a trade dress that is distinctive, that is non-functional, that is not the same colors that others use. It's not the same font that others use. Create something that's intentionally different and document that whole process to explain why you chose these colors or why you chose these fonts or why you showed certain designs or packaging, making sure that you're able to distinguish between what is ornamental, which is something that you can protect, versus something that's functional, which you're not going to be able to protect. Also, once you come up with a great design, make sure you use it consistently and all of the time. Make sure that that is what's out in the market. Don't make additional variations on that, because what you want to do is have a consistent look of a product that consumers can identify. And speaking of that, you also want to draw the consumer's attention to that unique element that you're claiming that is distinctively your brand. So when you advertise, you draw the consumer's attention to it by look for advertising. Put that in your advertising. Look for this particular color, this particular shape of box. The more that you promote the features of your trade dress, the more consumers are going to be able to connect that with your products and your products alone, and the stronger secondary meaning, we call it in trademark and trade dress parlance. But that is what gives you the ability to then stop others from using those same features. Again, document everything. Make sure that if you're investing in a new campaign to have this look for advertising, make sure you document all that, have all those figures. It's important to be able to show that you are investing and creating this reputation for your packaging. Any kind of media coverage, that's also great to have a stockpile of that. Anytime you get mentioned, especially if it's organically by third-party media, keep all of that, because all of that's going to become important if you ever do have to litigate and be able to defend this trade dress. Similarly, consumer surveys are a great way to be able to provide secondary meaning to show that, yes, all the investment that you've done in creating this particular design, it has caused consumers to identify you as a source. The litigator in me is going to tell you to be careful about consumer surveys, in the sense that if they're not conducted, during the process of litigation, it could be discoverable in a subsequent litigation. So you have to be mindful of that. But again, keeping all of these things in writing is something that's going to be helpful to you. And then once you've built this great trade dress, once you've built a design or element that people can really identify, what do you do with that? Then you have to enforce it. And you have to be monitoring what's going on in the marketplaces, both, online, where a lot of this is done, but also point of sale, in stores where your products are being sold. I mean, sometimes they're sold right next to each other. And, you need to be mindful of that. You may even need to talk to your retailers about doing something about that, or ensure that the next time you negotiate, there's something about that in the contract, so that that's not done. Once you identify infringers, people that are duping, go ahead, send cease and desist letters, and force your rights. Make it known that you are a brand that does enforce your rights. Sometimes a cease and desist letter is enough. It could either be a small player, maybe someone new starting, they didn't know, and they could stop. But in any case, you should do that to begin with, to let the market know that you are taking this seriously and you're going to enforce it. And you don't have to do it alone. There's trade organizations. We mentioned the INTA, International Trademark Association. I am on the board of that organization, and I can personally tell you that the organization does a lot in order to help its members with guidance and best practices, and even influencing legislations and rules. So take advantage of those resources, and also collaborate with other brands. There's always power in numbers, and perhaps you can combine efforts and maybe even share costs if there's one particular company or a few companies that you share this problem with. And then, leverage your in-house or outside counsel to take a look at your IP to make sure that you have all of these protections in place, that you have these foundations. Make sure you have a strategy for how you're going to monitor these products in the market, and then prioritize. We understand there's budgets and you're not going to be able to do everything all at once, but if you're not intentional about an enforcement strategy, it becomes more difficult. So prioritize your targets and make a concrete enforcement strategy based on that. So hopefully that gives you some good tips on what to do with our problems with duping. And now I'm going to hand it over back to Emily so she can give you guys an update on some legislation you should know about.
Thanks, Laura. So the first piece of legislation that we're going to talk about today have to do with PFAS bans that have gone into effect, that went into effect in 2025. So we touched on this a little bit last year because New York and California had enacted laws around PFAS chemicals, but the laws had not gone into effect yet. In 2025, effective January 1st, both of California and New York's laws went into effect. And taking a step back, PFAS is an acronym for a class of substances that are chemicals that are widely used in rain gear and shoes and camping clothes, really clothes, apparel, and accessories that are known for that need to be stain resistant or water repellent or extra durable. So think outdoor clothing, camping clothing, clothing for extreme sports, things like that. However, because PFAS are a class of chemicals, there are regulations surrounding how much of them can be used in certain clothing items and apparel and shoes. So California and New York specifically, they had these laws go into effect on January 1st. And in California, the law does not allow any person to sell any new apparel containing PFAS chemicals at or above a certain level that is identified by the state. And then in California's law is a little bit broader, and it prohibits the manufacture, distribution, or sale of apparel and other textile articles with intentionally added PFAS chemicals or a total organic fluoride content in excess of 100 ppm. We've also seen some PFAS legislation go into effect in Colorado on January 1st, 2025. This is really interesting because Colorado had previously had a PFAS ban on covering fabrics and other products. However, in 2025, a new law was effective that banned intentionally added PFAS chemicals to cosmetics as well. So it'll be interesting to see if more states, now that PFAS regulations have passed and have been enacted for apparel and shoe products, if states are going to start also moving to to cosmetics. And then, of course, in the EU is really pushing for a universal ban on PFAS chemicals, and we'll keep an eye out on that as well. And now I'm going to turn it over to Grace to talk about some more legislation.
Thanks, Emily. So 2025 was a big year for states getting on board with trying to legislate around AI. Notably, New York is our front runner here. 2 pieces of legislation went into effect this past year. The New York Fashion Workers Act, which we touched on a little bit last year, as well as the New York Digital Replica Law. Both of these laws are really geared towards protecting, in our industry, models and protecting their rights against having AI-created work products called digital replicas under both laws, which consist of any sort of AI-generated or substantially AI-enhanced representations of a model, either physically or even their voice. Under the New York Fashion Workers Act, the act requires model management companies doing any sort of business in New York State to obtain the model's written consent before generating any of these sorts of replicas. And the agencies also are required to provide models with information about how exactly the replica will be used, the duration, really trying to empower models to take control over any sort of AI creations based on their likeness. The New York Digital Replica Law expands the protection of anyone, not just models within our industry, but any person, used actors, any sort of simulations trying to be passed off that are created with AI instead of using the actual human. So interestingly, anyone working in New York really needs to take into account that both of these laws have gone into effect and the interest continues. Whenever you're working on contracts with, again, actors, models, spokespeople, anyone who will be altered or enhanced even with AI, your contracts need to include this broad consent detail and make sure that your contracts are being entered, up to snuff conditions. The person who you are using in your ads is represented, the use is made clear, all of that good stuff really is going to come under scrutiny. For both points too, the language of the legislation focuses on a threshold of how much AI you're using. So if you're using anything beyond, typical color correction or minor retouching, we would really encourage you to make sure your contracts include this language, especially moving forward. So while 2025 had a lot of activity, we're expecting the focus on AI to really continue this year. New York, again, our front runner here, has another law coming into effect June of this year. And this law similarly focuses outside of just the fashion industry, but any sort of commercial advertisements that are using AI. Here, the law is pushing to include an actual disclosure on any of this content that uses AI to inform viewers that AI has been used if you're using an AI performer or, again, AI spokesperson, really a broader reach. What we see with this law is less of a fear of AI and more of New York trying to work with AI. So it's not an outright ban, but it's trying to protect everyone's best interests, whether consumers or performers. Again, anyone working in New York should be aware of this and really make sure, like we said, your contracts are up to date and you're also being transparent with how AI is being used. Outside of New York, California is in the process of working on the California AI Transparency Act. It hasn't been passed yet, but similarly, this act would require any sort of company operating in California that uses generative AI to include detection tools so consumers can use that resource to identify if AI has been used. Moving forward, we expect more states to slowly get on board here. So we just wanted to spotlight the increasing presence of AI, both in New York, California, and again, we expect it to become more broad spread in the coming years. So I'll turn it back over to Laura to talk about medicalization of beauty for our beauty industry players here.
Wonderful. Thank you so much, Grace and Emily, for that wonderful update on the legislation. And yes, so for our beauty folks out there, we are going to discuss a big trend that you've all seen in this industry, this science-backed beauty. This is what consumers are demanding. You see with all these different types of products that are out in the market. I'm going to neither admit or deny what I've tried or what I want to try. But the point is that consumers are looking for these types of products. And it's becoming a big trend. And when something becomes a big trend that drives sales like this, people generally like to jump on the bandwagon and say that we could do that as well. And it's important that if you're going to be making these science-backed claims, that you back it up. Because if you're making claims about what your products are clinically proven to do or scientifically proven to do, those are efficacy claims where the FTC is going to want to know the proof. How are you making that claim? So if you're going to make claims like this, you need to make sure that you have all the testing to back that up. And it's not only for the FTC, because one thing we've noticed that even if the FTC is not going to come after a company for making certain claims like this that may or may not be substantiated, it's also competitors. Competitors can file lawsuits based on false advertising claims, and they too can challenge the claims that are being made in order to market these products that are more showing that it's more kind of medically favorable. So make sure you're not looking out just for the FTC, but also for your competitors out there. So if you're going to be making claims about your products, what your products can do, try to focus on the appearance rather than a specific result. So you can say it improves fine lines rather than it stimulates collagen, or don't call something Botox-like, because then that infers that there's some kind of medical formulation there. Again, focus on the appearance rather than results. Helps reduce the look of dark spots is better than saying it regenerates skin. Clinically tested, dermatologic tested, if it is, those kinds of statements would be okay. And so also in the marketing of the products, if you're using before and after imagery, make sure that you're working with folks that are actually operating within the right parameters. They are not making false claims themselves about it, and that you're certainly not using any touch-ups in these imagery. No AI models if you're going to be using claims about what your beauty products can do and showing a before and after model. Also, if you're going to be using any kind of facial scanning or taking any private information or photos of your consumers, be warned that privacy concerns are going to be involved. So you must, keep all of that information as well. And be careful about saying that you're diagnosing anything unless you are. Don't say that your products you're prescribing treatments unless, of course, you can substantiate all of those claims. So make sure that you follow those guidelines if you are jumping on this bandwagon. The next topic we're going to talk about, I'm sure it's something near and dear to everyone's hearts here. Over the last year, all the changes to our tariffs and imports and trade. And I'm going to hand it back over to Emily so she can give you an update on what's going on that.
Thanks, Laura. So looking back at 2025, we had a lot of changes to the tariffs, as Laura said. Taking a step back, what is a tariff? A tariff is a duty on imports. They give a price advantage to locally produced products over other products that are imported from other countries, and they also raise revenues for governments. In April 2025, President Trump announced sweeping reciprocal tariffs, and these tariffs, it places a 10% baseline tariff on almost all imports coming into the United States. And then obviously there were some other higher tariffs that were placed on other countries such as China, Japan, and Vietnam, which are huge manufacturing countries. Right now, the issue on whether the tariffs were enacted by the Trump administration pursuant to the International Emergency Economic Powers Act, otherwise known as the IEEPA. And the issue on whether the IEEPA allows President Trump to impose these tariffs has been presented to the Supreme Court, and we're awaiting its decision. A lot of people think it's going to come very soon. I checked this morning. I didn't see anything that was out yet, but hopefully we get that decision soon. And then similarly, similar tariffs, but moving on to the import side that Laura mentioned earlier during our overview, was another change that came in 2025. And this change came because President Trump issued an executive order in August suspending the duty-free de minimis treatment for all countries. And so prior to this executive order, shipments under $800 were allowed to enter the US duty-free with minimal customs formalities. And this was used really heavily by apparel brands, especially fast fashion brands, direct-to-consumer brands, and obviously consumers or companies that ship their products from overseas. So again, in August, the executive order suspended the de minimis treatment, the duty-free de minimis treatment with a phased approach. Obviously, this has had a huge impact on brands, including that more shipments are now being flagged or trapped in customs. Companies are now having to pass on costs to consumers that were not there before the suspension, as well as slowed sales and product launches, possibly because things are taking a lot longer to get into the country now. So in light of the tariffs, in light of the imports, what can brands do? The baseline is that brands should be flexible and should be forward thinking. So adopting flexible production models, expanding private label offerings, but also keeping an open mind to material substitutions. So some of the tariffs that have been imposed only target specific fabrics or materials. Brands should be open to potentially revamping or tweaking their products a little bit, working with your research and development teams or production and design teams to see if there's any equivalent fabrics or materials that you can use that are not necessarily subject to the tariffs. Also, adopting a flexible approach to pricing changes is important. Everyone is seeing that consumers are worried that they are bearing the burden of the tariffs due to the price increases of goods. It's really important right now for brands to keep their overall positive brand perception. And to do this, it's important to adopt a flexible approach when it comes to determining whether you need to adjust the pricing of your goods. So rather than throwing your hands up and raising prices across the board on every single product, it's important to be strategic about this. So one way that you could do this is to keep your core line of products at a steady price, the price that consumers are used to, that they're not going to balk at the store if they see that it's raised by a few dollars. But then in addition, introduce a higher price line, which might help to improve your margins. Another strategy that brands could implement is elevating mid-tier products. So elevating them by adding design upgrades or other types of upgrades or improvements for consumers to actually be able to, in their minds, justify the price increase. So these are just a couple of things brands can do. But like I said at the beginning, it's really important to maintain your overall positive brand perception and to keep the consumer in mind when you are trying to decide what strategy to take in light of the tariffs and in light of the new regulations on imports. I'm going to turn it over to Laura now to talk about the IEEPA tariff refunds.
Thanks, Emily. So this is just something that we wanted to mention really quickly, that if you're a company that has imported, a significant amount and paid a significant amount of tariffs at least over $500,000, probably to make it worth it, you may want to consider filing an action with the U.S. Court of International Trade in order to maybe be first in the line to get a refund if in the event that the Supreme Court strikes down the tariffs, saying that they were not legitimately issued. You may want to be first in the line by filing this lawsuit. The Court of International Trade has said that you can't use the regular protest that you would use if you were going to otherwise seek relief for overpayment of taxes. And this is something that you may want to consider. If you have, I'm not the expert on this, but luckily Foley Fab has trade experts. And if you're interested, just let us know. And I'm going to move this on to the next one. Just quickly talk about an interesting patent case before the ITC, the Lashify case. We don't have a lot of ITC cases usually, but it's something that you should consider because it's another tool in your arsenal to stop infringers right at the border. You don't get damages, but you can get an exclusion order. And the reason we wanted to mention this Lashify case is that it really does change an important element of what needs to be proved in order to be able to get relief under the this section of the ITC. And what this case did is that it basically expanded what was commonly known as the economic prong of the domestic industry requirement, which you have to show you have a domestic industry in order to be entitled to relief. And this case actually opened it up so that not only usually it was manufacturers that manufactured in the US would typically be able to meet this requirement and not importers. But the Federal Circuit issued a recent decision that's saying that sales, marketing, and expenses related to warehousing, quality control, and distribution does count towards providing in domestic industry. And it really is a change in how the ITC looked at this. And it's really important because one of the takeaways is that for folks that don't manufacture in the US, but still have a lot of labor and capital here in the US in order to make those products, they can now take advantage of the ITC process. And we think that post-Lashify, it's going to increase the use of ITC for folks that were originally just importers that didn't manufacture here. So we're going to be keeping an eye on that. Next, Emily, I'll send it over to you.
Yes, the next case we have in this section has to do with patents as well as trademarks and trade dress. However, this one is between Lululemon and Costco. So Lululemon sued Costco, accusing Costco of selling unauthorized dupes. Here's the word dupes again. And this is not self-dupes, though. This is dupes by a third-party company. But anyways, Lululemon accused Costco of selling these dupes of their scuba product, the Define jackets, and the Align pants. And so Lululemon alleged that the dupes constitute trademark, trade dress, and patent infringement, and that these include the stitching on the Define jacket, certain aspects of the scuba hoodie. And in its affirmative defenses, Costco asserted that Lululemon's Define trade dress is not a source identifier, and that the scuba mark is generic. And with respect to this section that we're talking about, that 2 of Lululemon's patents are invalid. On September 2nd, the court allowed Jacques Murray to intervene as a defendant in the action because Murray is a company that designs and sells some of the accused products to Costco. In Murray's affirmative defenses, they also claimed some of the same affirmative defenses, as well as that the Tidewater Teal trademark has been abandoned through genericide. So we'll keep an eye on this one. It encompasses both trademark and patents, but we thought it was relevant since it was pretty recent. The next case that we have in this section is Deckers v. Last Brand, DBA Quince. This is another duping case. And basically Deckers, who owns the UGG brand, is suing Quince for infringing Deckers trade dress and a few of its UGG boot designs. They're also claiming patent infringement as well. So the patent issue, Quince asserted affirmative defenses saying that the patent is invalid. Both parties moved for summary judgment, with Quince's summary judgment claims focusing specifically on the design patent issue. And here, Quince argued that the Deckers patent infringement claim fails because the design patent is functional and indefinite. The court, after reviewing the parties' motions, declined to invalidate Deckers' patent, and it held that Quince did not meet its clear and convincing burden to show that it's functional or indefinite. So the parties have a trial scheduled for June 10th on these issues and on the remaining issues that were not addressed during summary judgment. So it'll be interesting to continue to see what happens in this case. I'm going to turn it over for the CLE announcement now.
Thank you. At this time, I will announce the CLE code. For those seeking CLE credit today, please enter the following code on your form. It will be CUHB0 Again, that's CUHB0. Thank you. We'll continue on.
Now, Kristen, if you can fill us in on some of the labeling compliance issues, that'd be great.
Thanks, Laura. While we could probably do an entire separate presentation on labeling rules and compliance, we only have a few minutes left today. So I wanted to focus on an issue that's likely of particular interest to many of today's attendees, and that is the Federal Trade Commission's CARE labeling rule. This rule was enacted in 1971, and the purpose of the rule was to ensure clarity and truthfulness of care instructions on clothing and apparel. And it certainly had a positive impact, but in the 50+ years since its enactment, the rule is certainly lagging a little bit, especially in today's modern digital age. The rule requires that textile wearing apparel labels state the regular care needed for ordinary use of the product. And this includes washing, drying, ironing, bleaching, and warning instructions. And they're required to be on a printed permanent care label affixed to the product, which I'm sure we are all very, very familiar with. The rule also requires any other appropriate terms for care so long as they are clearly and accurately described on the label. So many companies opt to also include proprietary care icons or to include international symbols. But because of the rule, these icons also need to be supplemented with corresponding written terminology, and this creates a redundancy on labels between symbols and terminology. Moving on to the next slide here, these are some symbols that the rule does allow. So in 1997, there was an amendment to the rule, and as amended, the rule did permit manufacturers and importers to permanently affix certain symbols that come from this ASTM standard listed here. These are the only symbols, however, that manufacturers and importers can include without terms. The FTC considers noncompliance with these requirements, including the failure to permanently affix a care label with printed care instructions, as an unfair or deceptive act or practice subject to civil penalties and other enforcement mechanisms. So compliance is extremely important. Now, the care labeling rules, strict requirements for this written care terminology or the use of symbols from the ASTM standard that we listed has some tension with some international standards that have come about in recent years, including the European Union's General Product Safety Regulation. While the FTC's framework focuses primarily on clarity and truthfulness of care instructions, the EU's GPSR mandate mandates that instructions be provided in a language which can be easily understood by consumers as determined by the member state in which the product is made available on the market. So the point of this is that the official languages of all the member states in which the product is already sold, which is 27 in the EU, need to be on the label. So that means all of your terms need to be translated into that language. And if a company fails to comply with this requirement, it risks fines in member states, sales bans, or other enforcement mechanisms. So what do we do about these issues? Well, there have been some suggestions. However, the FTC has not done anything yet. Some industry actors have advocated for change, and that includes the American Apparel and Footwear Association, who did submit a petition for rulemaking concerning the digital label of apparel to the FTC in the spring of 2025. And that petition garnered a lot of public comment. So while the FTC has not yet acted on that petition, I have listed some thoughts here on how the rule could be modernized, especially with globalization in mind. And one of those points includes using QR codes or other digital labeling. We also have thought about some other things that folks might want to consider, or the FTC might want to consider more specifically, which is the acceptance of international care symbols, which many companies already use, the harmonization with global language requirements, so that GPSR requirement, and also potentially clearly distinguishing between essential and non-essential care instructions. So we will see what the FTC does next. Now I'm going to pass it back off to Grace.
Thanks, Kristen. So 2025 was certainly an interesting year for M&A activity. we're going to spotlight two of those transactions that certainly garnered a lot of attention here and wrap up with some key takeaways as we look into 2026. So the first transaction we'll discuss was Prada's acquisition of Versace, which closed last month. This transaction was certainly all over social media, and the excitement among consumers was tangible. Interestingly, Prada and Versace have distinct aesthetics that you wouldn't normally consider go hand in hand, but this really emphasized what brands are doing in terms of expanding their own portfolios and how two seemingly opposites can come together for a really great success here. So with Prada's acquisition, they were gearing up ahead of time, expanding their Italian manufacturing system. I believe they spent over $200 million the past 5 years to really improve and strengthen their manufacturing system, which they plan to envelope Versace right in. Doing so will enhance both brands' production capacities, reduce costs, and overall further Prada's commitment to environmental considerations. So on the outside, this was an exciting acquisition, and we're interested to see what the brands end up doing together. But on the back end, it also really speaks to how in the M&A context, it's not only what's being presented to consumers, but how brands can capitalize behind the scenes on operational efficiencies and reduce cost in the long run. The next transaction we're going to discuss also garnered a lot of attention, especially on social media. This was e.l.f.'s acquisition of Hailey Bieber's Rhode brand, which closed this past May. So interestingly, this transaction, although it was promoted as having a $1 billion price tag, $800 million of that was paid at closing, with the excess $200 million to be tied to an earnout over the past 3 years, which really evidences e.l.f.'s belief in Rhode continuing to be successful and what the partnership can do together. So e.l.f., as I think many of us are familiar with, is primarily in different retail shops, whereas Rhode has really garnered popularity online through social media marketing. This collaboration is going to help bring Rhode into more physical stores and also, again, kind of capitalize on Gen Z's interest in the brand with e.l.f. and attract kind of a refreshed consumer interest here. So what we can kind of take away from these two acquisitions, as well as many others that closed this past year, are one, the role of social media. And again, Gen Z is really emerging as a subsection of the market that brands really need to be considering in terms of their marketing, their spend, and their influence, which extends beyond just the Gen Z demographic, but into their households as well. Access and affordability. While quiet luxury has been trending the past few years, we are starting to see a shift for consumers looking for more affordable luxury, still high quality goods, but along with the self-duping discussion, brands offering more price points among their products to continue expanding their consumer base. And then, as mentioned, in connection with the Prada and Versace acquisition, really becoming more strategic behind the scenes on how brands can best expand their portfolio while still focusing on sustainability, efficiency, and other ways for brands to come together that you may not traditionally think of in that sense. So we expect all three of these takeaways to continue onwards into 2026 and are excited to see what the M&A future holds. With that, I'll turn it back over to Emily and Laura for cases to watch.
Thank you so much, Grace. So we've already mentioned a couple of the cases that we're going to be watching this year. We're going to keep our eye on the Adidas Aviator Nation case, the Lululemon versus Costco case, and the Deckards versus Quinn's case. But we wanted to end by mentioning another matter that we are closely monitoring. As many of you know, Saks filed for Chapter 11 bankruptcy protection on January 14th. It's not surprising. I think that people thought that this may be coming. And that during the time, it's kind of moved pretty fast. There's already initial orders that have been in place for critical vendors and also their consignment partners. SATS is expected to continue operations during this proceeding. They've already gotten this financing. It's probably affecting a lot of you on this call because according to the public statements, there's 10,000 to 25,000 creditors. And we just listed a few of them. So ultimately, it's too soon to tell how this is all going to shake out. But it's certainly something that we're going to be monitoring and continue to let you know if there's any developments. And with that, we are exactly at the hour, and we'd like to thank everybody for attending. We hope that you did, in fact, get some takeaways and that you found the program to be valuable and interesting. And we'll see you next year. Thank you.